Morning. Morning, Council. Good to see you. Court calls 6204 Juan Francisco Chavez Uribe, State of Texas versus, for announcements for pretrial.
Your Honor, Brittany Irving on behalf of Mr. Chavez Uribe. I did send him the link for today. I'm not sure if he is on, but I am getting ready to start a trial in front of Your Honor, and so I would ask that this case be reset.
What says the state?
Judge Dan Water for the state. Judge, we'd ask that his non-appearance be noted and ask for a reset in light of the fact that counsel is in trial.
Reset is granted. Reset date, please.
March 26, 2026 at 1:00. Thank you.
Cause number 5701, State of Texas versus Juan Pablo Verdines Urbina.
Your Honor, Dan Water for the state.
Good morning, Judge. Elizabeth Moore for Mr. Verdines Urbina. I do not see him online yet, but I will just check in with him and make sure that he joins.
Judge, I think we have an announcement on all these cases where there's been a writ. We've been going back, Ms. Moore and I've been going back and forth with regards to subpoenas and witnesses. We've hashed out pretty much a stipulation, Judge, where we'll be able to, or Ms. Moore will be able to read that into the record, and that would eliminate the need to bring in these witnesses and rehash whatever issues. We'll stipulate to that, and that way, at that point, that they can do what they need to do as far as any type of appeal. Now, with regards to that, there's, I think, one issue that we will not stipulate to, but we will provide the jail records or the reports of inmates that were held during that time. That should take care of everything. Along with that, Judge, I'd also note that because the Office of the Attorney General also filed their motion to quash a protective order, and that would alleviate that need and that need for the court to hear any of this. So if we can just get a reset, Judge, we will have that issue ironed out, and then Ms. Moore can either file that with the court and we can move forward without having all these witnesses come in to repeat.
I will just correct that the stipulations alleviate the need to call some of the witnesses. We still have some witnesses that we will be calling, and we're ready to proceed with those witnesses today. The stipulations should eliminate the need to call the sheriff as well as the troopers, troopers who are involved in arresting these 5 individuals. But we still have a number of witnesses that we will need to call that will include Victor Escalon, Claudia Molina, and Norman Madrigal. But the other witnesses, because of the stipulations and because of motions to quash, which I also have a couple of things I would like to address about those, we will not need to call the other witnesses.
I called 5701, and now you all are, what are you all talking about? All the rest of the cases set for this morning as well as 5701, or what are we doing?
Yes, Judge, it's all of the cases that have the writs and the motions to dismiss filed.
So that would be 5701, 969, 587, 1104C, 5790, 1108C, 5860, 1109C, 5940, and 1118C. Is that correct?
Yes, sir.
That's
So
correct.
this argument that you all were making applies to all of those cases that I just stated.
Yes, sir.
Okay.
Yes, Judge.
will we be going forward with any of those matters this morning, or is this announcement to reset all these cases until these stipulations and other issues are resolved?
I'll be ready to proceed this morning, Judge.
Counsel for the state?
Judge, if their witnesses are available, and I know that the Office of the Attorney General had filed a motion to quash. I'm not going to make their argument for them. I know that Mr. Molak had filed had filed his inability due to some medical issues, medical appointments that he had scheduled. But I know that
I did not see that, though. Yeah, okay.
Yes, and we understand the court's previous ruling on the motions to quash. I just wanted to make sure that the record was clear about the subpoenas. We did serve these witnesses in person and they were returned properly. There were a couple of matters that I wanted to address because like I said, the first issue that was addressed in the court's ruling was the service. So we believe that we properly served the subpoenas initially, but we did serve them in person this time around. And so hopefully we can narrow the ruling to be specifically about the sovereign immunity issue. I just wanted to get a ruling on that issue specifically today. I'm going to assume that the court is
Also
going to
filed a motion of unavailability, counsel, so he needs to be here to be able to address your request for rulings, doesn't he?
he does, Judge.
I just was under the impression that the court would continue the ruling from the previous subpoenas, but I just wanted to narrow.
Well, I am going to do that, but you're saying that you remediated some of the issues that were there and still wanted an additional ruling concerning that, and he needs to respond to that request.
Understood, Judge.
Okay.
I did have another matter with regard to the subpoenas that I wanted to put on the record, but if we wanted to have another hearing, I'm happy to save that issue for then.
Well, I just believe he's a party and he's filed some motions and now he's saying he's unavailable for a valid reason. So I don't know if I can proceed on any of these in view of that his unavailability.
Understood, Judge.
And I don't think a short recess is going to prejudice anything. We've been working on these issues for quite some time now. So I think we can come back on the 19th. I believe that's the next time I'm here in session to hear all of these matters.
Understood, Judge.
Is there any problem?
With regard to the other witnesses that are not those two witnesses, would we be able to proceed today or would you like to proceed on the 19th?
On the 19th.
I'd like to keep everything together.
Yes, I agree. So let's come back on the 19th and consider these motions in the view of the unavailability of counsel for the Attorney General's office. Reset to February 19th, 2026 at 1:30, is that? 1:30 p.m.
Yeah, I just bought in. David Silberthaw. I'm co-counsel with Ms. Moore from Texas Rio Grande Public Defender. I just want to make sure that the court, just to be really clear about, because I know these matters have been going on for months. I think that there was two issues. In the last time on the subpoena issue, one was a service reason for quashing, and the other was sovereign immunity. And so the intention behind this was simply to make sure that, to the extent that service was part of the reason why the subpoenas were quashed in the past, that's cured, and that we can really narrow the grounds for the quashed subpoena on sovereign immunity grounds. We're not really asking to relitigate the merits of the sovereign immunity argument or anything. We just really wanted to have a sort of a clean record that to the extent, again, that the service was part of what was the issue before, that's not, that we've cured that aspect of it. So I just want to kind of be very clear for the court, all parties, because I know this has been going on for a long time and things are being reset. So I just wanted to sort of just make sure everybody's on the same page with that.
Well, I don't think any party would have any objections to the court ruling on that. But I just, I think it's obvious if there was service, there was service, so that part of the ruling could be, I guess, stricken, and we can just go on the sovereign immunity. But I don't know if the state would have any objection to that. Maybe if you need something before the 19th, I would suggest that you maybe circulate a stipulation and maybe get the Attorney General to sign to stipulate that they would not have any objections to that issue being stricken from the ruling, and then I wouldn't have any problem signing that, because it's quite obvious to me. But again, their unavailability, I think, prevents me from ruling on that in the absence of a stipulation from there.
Thank you, Judge. I appreciate that. That's helpful guidance for us.
Thank you. Okay, February 19, 2026 at 1:30 p.m. We'll resume all matters, and I assume if the defendants were not present, the state just would ask that their non-appearance be noted and case be rescheduled without any capiases. Is that correct?
Yes, sir.
Thank you, guys.
Thank you.
Ma'am.
Thank you, Judge.
Recess. Anything more on the docket for the
Repeat it again, Judge.
Sorry, I was muted. The court calls the Jim Hogg County District OLS docket for this morning, January 26, 2026. First case on this morning's docket is cause number 24 CRJ 21, the state of Texas versus Eric Brandon Carranza.
Brittany Irving on behalf of Mr. Carranza. Good morning.
Morning. Raise your right hand, sir. You solemnly swear or affirm that the testimony you're about to give in this cause shall be the truth, the whole truth, nothing but the truth, so help you God? State your name. Announcements, please.
Your Honor, was that for an entry of DCO? My understanding is also that Mr. Carranza is currently in custody due to an STA. My understanding from Ms. Irving, after speaking with her judge, she did not receive notice. We have, I believe, reached an agreement, Your Honor, to reinstate his bond at this point for the court's consideration.
That's correct, yeah.
Bond as originally entered is hereby reinstated, sir. Hereby ordered released. Reset date.
The DCO will be pre-trial, February 5th, 2026. Announcement, February 19th, 2026, and trial, March 5th, 2026.
You've heard all those dates, sir?
You heard the date, Judge.
Thank you.
Thank you.
Excuse me, under that state, the trial will be March 19th. Sorry for that. March 25th.
March 25th.
Calls 24 CRJ 27, State of Texas versus Jose Abraham Salgado. Raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give in this cause shall be the truth, the whole truth, nothing but the truth, so help you God? State your name. Announcements.
Your Honor, my name is Brittany Rios. For the record, I am the legal assistant for attorney Mr. Silverio Martinez. He's been waiting in the waiting room to be let in. I don't know if the court can let him in.
We Get him in here. Is he an attorney or who is he?
He's the attorney. He was in already, Judge.
Okay. Announcement from the state?
Your Honor, we're going to set for a motion to adjudicate guilt, Judge. We did tender over an offer to defense. I have not reached an agreement at this time.
Your president ready to proceed?
I don't believe so, Your Honor. We did receive a motion to set bond on this case, Judge. I believe the defense is currently asking for $10,000 personal finance bond, Judge, based on his criminal history. He does not have any criminal convictions. We're not opposed to the setting of a bond, Judge, and a resetting the case.
And, bond as requested, you have no objection to?
So,
Counsel?
Good morning, Your Honor. Silverio Martinez for the defendant. Is this the case? I didn't hear, I'm sorry. Is this Jose Abraham Salgado?
Yes.
Okay, yes, Your Honor, I just, I filed a notice of appearance on this case and a request for bond. I didn't quite hear what the prosecutor just said, but we're asking for a bond. I don't know if we have an agreement.
I believe so. Counsel, the state requested a personal recognizance bond, $10,000.
Okay,
Correct, state?
that is coming from defense, Your Honor, and we have no objection to that request.
Request is
that'll
hearing.
work, Judge.
Bond is set as per the agreement.
Thank you. Is that all the charges, or are there any charges without bond, Your Honor?
Isn't that your job to be figuring out, counsel? The case
Yes,
act
Judge.
morning is CRJ 27. That's the one that I'm addressing.
Okay, just making sure. Thank you, Judge. I apologize for that.
You said dates?
The pre-trial on 2/5.
February 5th, 2026 at 1:30 is pretrial.
Announcement February 19th,
Announcements February 19th, 2026 at 1:30.
and trial March 26th.
March 26th, 2026 at 1:30 is trial.
Your Honor, if I may, Judge, this is a motion to adjudicate. How many just ask for one reason?
Oh, just one, it's gonna be the February 5th.
February 5th, then I'm sorry. February 5th is your reset date, sir. You understand that?
Thank you.
Excuse till then. Thank you. You'll be hereby released.
Thank you, Judge. That's all I have. May I also be excused?
Yes, you may, counsel. Thank you.
Judge.
23 CRJ 26, State of Texas versus Felix Leal.
Your Honor, the state does have an announcement on the case, Judge. 23 BCRJ 26, evading arrest detention with the vehicle, Your Honor. We are going to be filing, or the state's going to be filing a motion to dismiss that case, Judge. The case is unable to prove beyond a reasonable doubt. We would like to urge our motion at this time, Judge.
Response.
Defense is unopposed.
So ordered. Case dismissed.
Thank you.
24 CRJ 84, State of Texas versus Felix Leal.
The state's now ready, Judge.
Defense counsel is ready pending the taking up of the motions and ruling it.
That's the extent of the document. Okay, so. Where is Mr. Leal? Is he present? He is? Okay, great. Let me just take a short recess and talk to counsel in chambers.